Worship, I can further refer the court, I'm not going to quote from them, but two important cases is State versus Bennett, B-E-N-N-E-T, 1976, volume 3, SA, page 652, and it's a Cape Provincial Division. And specifically at page 654, it also deals with the factual basis that is required. Now, on that point, Your Worship, in S versus Bennett and S versus Barber, and specifically then in S versus Van Wyk 2005, volume 1, South African Criminal Laws, Law Reports, paragraph 41, it's a Supreme Court of Appeal decision at paragraph 12. It was stated that the primary purpose in the inquiry of a bail application is, and whether to grant or refuse bail, is whether the applicant will firstly stand his trial, and secondary to that is whether it would be detrimental to the administration of justice. Now, Your Worship, it's conceded by the state that there is no flight risk. We can accept that there is no likelihood, and we can accept that the applicant will stand his trial. When it deals with the administration or whether it's detrimental to the administration of justice, we then look to whether the integrity of the investigation will be preserved. I have addressed the court that there is no factual basis to find that there is a likelihood that he will interfere or intimidate witnesses. And I would submit, Your Worship, on that basis, there is sufficient evidence before Your Worship to find that the interest of justice to permit the applicant's release out on bail. I would like to finish off, Your Worship, and point the court, which I believe the court will be well aware of and take cognizance of, is that at the bail application stage, the court always has to take into consideration the presumption of innocence in this matter. That was so reiterated in State versus Dlamini, Gladla and Skietekat, the matter I referred to, Your Worship, to earlier, but specifically again dealt with by the Supreme Court of Appeal in Crossberg versus S, C-R-O-S-S-B-E-R-G, Crossberg versus S. The judgment is available on SAFLI, being case number 439 of 2007, ZASCA, and it is the 93rd judgment of that year, delivered on the 22nd of August 2007 rather, and specifically at paragraph 13, the court reiterates that in a bail application the presumption of innocence is intact. And importantly then in State versus Atchison in 1991, volume 2, SA Law Reports, page 805, it's a Namibian decision, specifically page 822 at paragraphs A and B. The court again finds that there is a presumption of innocence, but goes further to say that a bail application is not there for prospective punishment and to detain an applicant due to the seriousness of the offence. Now I would submit, Your Worship, and implore that the court finds that the applicant has shown evidence on oath that it is within the interest of justice for him to be released out on bail. Now I would submit that Your Worship then grants him bail as such. My ending remarks would be, Your Worship, that I believe if the court has any fears insofar as the likelihoods is concerned in section 60 subsection 4A to E, the court in State versus Browncoon 2007 specifically deals with it that these fears may be allayed by appropriate bail conditions, and I believe, Your Worship, that if appropriate bail conditions is placed upon the applicant, the court should find that it is in the interest of justice for him to be released. Worship, those are my submissions, unless the court wants to hear me on a specific aspect. Thank you.
Your Worship, the argument that was made by my colleague is in essence what I'll call a Section 35 argument in as far as his right to the presumption of innocence is concerned. And most of the submissions and the cross-examinations and the evidence in chief was spent mostly attacking the version of the state. And as
partly hit in the postponement.
As far as Ms. Wright informed me, she informed me that they opened a separate court, but that was when Mr. Khabis going to assist in as far as the postponements. However, the one matter of Manare is when your worship is involved and yes, worship. The one of Mutuki, I'm not sure, the one I was doing with Mr. Kalaute for your worship, I'm so not sure whether they were able to postpone or not. My colleague was here and I'm just not sure as I stand whether those matters have been fully dealt with or whether there are any matters that might be waiting for your worship. Perhaps unless we could be assisted by one of the court readings in ascertain from Code 19 as informed sitting in Code 19 to ascertain whether all those matters have been dealt with and if the worship would be needed in any of those matters. Not the investigative side, also the personal. Mr. Somere is also here for that matter that you requested that he comes for being then the party had to pay the application. He says he just received a message from Ms. Wright at the Metro Fed. They say they intend on postponing that matter to a certain date. I informed next week Thursday, Your Worship. And then I will show whether Your Worship will be available. Nothing just related with Mr. Allowed Mr. Kamat is making just so I think the matter might be not
You can proceed. You still have time.
Your Worship?
You can proceed with your argument. You can still have time.
It's not 4 o'clock, Your Worship. I don't think I'll be comfortable proceeding in as far as until I feel like I'll be rushed in every point that I want to make. That is what. I'm not sure to your worship's availability, but as I said,
Thursday.
yes, Worship, next week Thursday, I'm available.
Mr. Van Rensburg?
For this matter specifically. Your Worship, I'm unfortunately unavailable from Monday for quite some time. I don't want the matter to be delayed due to that. I've presented my arguments to you. I will ask that my instructing attorney will take over from the next day. But may I just inquire from him if it is indicates.
Okay, the date on Thursday. You can.
Yes, it is the 10th, Your Worship. You are right.
Mr. Van Rensburg?
Worship, yes, I confirm 7 are available, Your Worship.
Matter is postponed until the 10th of July 2025 for address by the state and possible judgment. If you are in custody, you shall remain in custody until then.
I just did my back.
Where's the copy?